thank you so much to the Peel Halton Workforce Development Group for having me here today to discuss some of the key HR law implications of the COVID-19 pandemic. So, as Angelica mentioned, I'm a lawyer and workplace investigator, and I include my picture here to give you the opportunity, to tell you that in that role, over the course of the pandemic, given the kind of work that we do, our firm has had the opportunity to speak with hundreds of employers over the course of the pandemic. And as a result, we've been able to put together essentially a heat map of the key challenges and pain points that they face as they try to navigate the constantly shifting landscape that they've all really been facing over the last, well, I was going to say year because I keep saying year, but over the last 20 months or so. And so for today, there are a couple of key issues that I would like to dive in with you because there really are so many implications that the COVID-19 pandemic has had on how we work, when we work, where we work, that it really would be impossible to cover them all in the time that we have today. But the couple that I do want to touch on are starting with the current climate, just to assess where we're at and how that has impacted the workplace and how employers carry on business. One of the key things that we've identified in terms of the heat map of pain points is the entire return to work process. So we'll talk a little bit about return to work and how that's shaping up over the last few months. We're also going to discuss vaccination and the new developments related to vaccination policies and vaccination mandates, and conduct issues in the workplace. And then finally, I want to take some time to go through with you a new legislation that's really just come up recently that is really related to some of the kinds of things that the pandemic has. Sorry, I'm just saying that some people are having issues with audio, and I just want to make sure that if somebody can tell me if you can hear me pretty clearly.
I can hear you. I think it's good. I think some people are having a few issues. So if you're having trouble with your audio, can you just make sure that your volume on your end is up on full? And a lot of people are saying that it might be best to open in the Zoom app. Okay, sorry, Alex, continue.
Thanks so much, Angelica. I just, the beauty of technology, right? Changing how we work. I love technology. I wouldn't want to know what the pandemic would have been like if we'd had it 20, 30 years ago instead of now in the era of Zoom and Teams and whatnot. But it's fantastic until it isn't. So I'm always very conscious of, that everything is working and that I haven't done something on my end, so you all can't hear me.
No, we're good. You're good.
So just to close off our session roadmap, then the last thing we'll touch on is this new legislation, which is presenting a couple of things that are going to be very interesting for employers and, again, very key to navigate the rest of the pandemic, but also, the years going forward, because this is intended to be more of a long-term thing. And so just to start off with the current climate. As I mentioned, it's been quite some time since the start of the pandemic. It's been more than 20 months since mid-March, when really employers had to start reacting to the widespread closures that had started and all the public health measures that were put in. But in a lot of ways, we're still in a phase that's somewhat like the early days, in that things are constantly changing. Initially, a lot of employers took a reactive approach because they simply had to. More or less, the pandemic-related measures came out of nowhere, and a lot of employers were required to pivot to different models of work. Increasingly, as the pandemic has gone on, employers have had the opportunity to address potential issues proactively. And also, some have really leveraged the benefits of the changes that have happened in order to improve their business processes and make their businesses more efficient. Some, unfortunately, haven't had that opportunity just because different industries have faced different challenges. As a result, some employers have really decided that they're not going to go back to pre-pandemic business as usual, while others have been waiting for things to stabilize with the intention of going back to just that. But now what we're seeing is that Ontario is facing what's being called a substantial fourth wave of the COVID-19 pandemic. There's a new variant of concern, but on the other hand, we have more than 75% of Canadians fully vaccinated. And that's as of about a week and a half ago, because it takes some time for the numbers to be put together and published by the federal government. And that's not Ontario specific, that's across the country. But really, because of the new variant of concern, the new wave, we know that the government had released a plan to safely reopen Ontario and manage the COVID-19 pandemic for the long term. And as part of that plan, it was planned to lift pretty much all public health and workplace safety measures by approximately the end of March 2022. That plan has been paused now as of November 15th because of what's currently happening with respect to public health. And it's not clear how that's going to impact the anticipated trajectory and the anticipated end date of this sort of exit step from our public health related measures. Additionally, with numbers going up, the fourth wave, to a certain extent taking off, there's now renewed resistance from some employees to returning to work and resistance to policies and procedures on all sides. Employees who might be, pro-vaccination policies may be concerned about health and safety now that there are more cases happening, now that there's more risk of exposure, and now that there's this new variant. Employees who aren't vaccinated, we're finding from what employers are telling us, are actually also pushing back on vaccination mandates and saying, people have been told to be vaccinated, numbers are still going up. Why do I need to be vaccinated? I don't think this is necessary. Why can't I just stay and work remotely as I have been for months now? And so really the thing to keep in mind throughout this whole presentation and just going forward is that we're in a constantly shifting legal landscape. It's been so dynamic. And if there's one thing that you take away from this, I will say that it's so important for employers to really keep their fingers on the pulse of what's happening. And again, given everything that's happening, we can't really cover all of the HR law implications, even the ones that may have changed from a month or two ago, because things are constantly shifting, new things are constantly being introduced. But we will do a deeper dive in the couple of items that I had identified. The first one is return to work. And so really, again, many organizations have significantly changed how they work. Not all have been able to, but even organizations that generally don't have, that don't operate in the kinds of industries that are really amenable to a work from home environment might have pockets of their workforce that have been working remotely, their office staff, things like that. And so remote work has seen a massive uptick in Canadian workplaces because of the pandemic and due to the existence of services like Zoom, like Teams, Google Meet, WebEx for those who use it. And while, given where we are in the pandemic, we're no longer in a situation where remote work might be required because businesses have been told that they can't go into the office. There are a lot of employers who have decided to keep doing remote work on some sort of hybrid basis or a temporary basis. And there are a lot of employees who have begun to prefer remote work. So as the pandemic situation improved, really a lot of organizations started to either return to work, either fully or in a sort of transition phase. And a lot of larger organizations were really planning a return to work for early 2022. Now, because of the constant shifts that have really required employers to monitor and assess the situation, some of these have been moving goalposts. And a lot of return to work dates have been delayed by the fourth wave. Some employers are even rolling back their return to the office, because as the numbers go up, they're looking at where the numbers were previously, where they might have been in their return to work plans. They're considering if anything has changed. And some of them are saying, okay, maybe we'll wait a little bit longer and we'll see what's happening, because how we're working now and how we were working during the pandemic may still be working for us. In doing these sorts of things, employers are really considering the kinds of health and safety risks that are at play. Because again, the more numbers we have, the more potential risk for exposure and the potential risk for liability for employers if they're found not to have taken all reasonable precautions to protect the health and safety of their workers, which is, worded differently in different provinces, but generally across Canada, that's really the obligation that employers have with respect to health and safety. And as I mentioned, with all of these things happening, there's an increased resistance to return to work. And really, what employers need to keep in mind is that there may be some situations in which they have to accommodate employees who are unable to come into the office. We'll talk about that more in a couple of minutes. But generally, when an employee has a job-related requirement that stems from a human rights-related protected ground, and this is usually disability in a lot of cases, with employees who are saying they're immunocompromised, they can't come into work because they're at a high risk of contracting COVID-19, or if they contract COVID-19, of having very significant symptoms. But sometimes the accommodation requests have been related to family status due to employees who may have additional elder care obligations, child care obligations. To a certain extent, these have somewhat stabilized with school programs stabilizing how they're operating, but they do still exist. And because people have had to change who they interact with, how they live their lives, some have still had significant impacts that they're turning to their employers to try to accommodate family status related needs. When accommodating requests to perhaps not return to the office or return to the office in a more limited capacity, employers need to keep in mind what they've been keeping in mind since the start of the pandemic, and really much before that, which is that accommodation needs to be done to the point of undue hardship. And that's a very high threshold, and it imposes a significant burden on the employer, because things like a slight cost increase in doing business or inconvenience on the employer's part aren't necessarily going to allow the employer to say that accommodation isn't necessary and to deny an accommodation request. And with the increased resistance to return to the physical office, what a lot of employers are also struggling with is the fact that even where there might be no accommodation need, there is a risk of losing employees. And part of what we're seeing now, and what many of you may have heard called either the Great Resignation or the resignation boom, is that a lot of employees are leaving work. They've taken time over the pandemic to really reassess where they are, what they want, and they've decided that maybe they don't want to be in the kind of job they're in, they don't want to be in the industry they're in, or they're just reprioritizing their lives. This is leading to a lot of employers really struggling to find talent, and so sometimes being a little bit concerned in terms of imposing a strict return to work plan, because they don't want to lose employees who have been very productive throughout the pandemic in a remote context. With remote work being so prevalent, some of the same things are relevant now that have been, again, throughout the pandemic. For employers who have remote workers, there can be quite a few areas of employment standards related liability. Vacation entitlements and vacation related liabilities, I have on there here in the context of remote work. It really is related to wherever employees are working. But in the context of remote work and the pandemic generally, employees, until somewhat recently, haven't been taking vacation very much. Now that numbers are going up, some employees who had planned to take vacations at the end of the year, again, have chosen not to do that for various reasons. And what employers should keep in mind is that employers really are required to make sure that employees are taking at least their minimum vacation entitlement annually. So in Ontario, under the Employment Standards Act, that's 2 weeks of vacation time per year. And for employees with 5 years of service or more, that's 3 weeks. Even if you were to pay out the vacation pay, employees are still entitled to take their time. And if they don't decide to take it, it's actually imposed on the employer to tell them that they are required to take that vacation. Similarly, while some employees may not be that interested in taking vacation now, they may be asking for carryover where an employer may not have had carryover before, so they can take it later on. Employers should keep in mind that the Employment Standards Act is really a complaints-driven kind of regime. Um, Absent an audit that tends to look at some specific things from the Ministry of Labor, really the way that employers most commonly face liability is that an employee will go and bring a claim and say that they didn't get something they were entitled to. So an employee could bring a claim for unpaid vacation entitlements, or in vacation entitlements they didn't get, even if they were paid the money, but they didn't get the time. And for some employees, this can add up over the 2 years that they generally have to bring a claim. Additionally, employers really want to make sure that they're ensuring vacation is taken as much as possible so that there isn't a flood of vacation requests. And to the extent that you may have employees who haven't taken vacation during the year, it's really important to consider, well, maybe you do want to make an exception and have a little bit of carryover so that you're not operationally strapped as a lot of employees try to take time around the holidays or into the new year. With the changes in public health measures, another complication that employers are struggling with and may continue to struggle with into the new year is travel policies. If employees choose to travel, and then in a lot of circumstances now, quarantine requirements have been waived or minimized, but some employers have decided to go above and beyond public health requirements and have employees stay home for some time, even if technically they could return to work after either domestic travel or international travel. And so these things should be factored into time when an employee might not be available to perform work. And so again, while throughout the pandemic, things have come up and employers have had to be reactive, towards the end of the year and going into the new year, employers would be really well advised to take stock of any exceptions they have made, consider whether some of those exceptions are now policies they want to keep up, in which case they should be formalized, or if they want to reset expectations to before the exceptional time that the pandemic has been, and tell employees, okay, we did do this now, but that was an exceptional circumstance. That's not how we're going forward. And in the future, here's what we're going to be doing with respect to vacation. Similarly, another area of liability and another pain point for employers has been overtime and record keeping. And when we talk about employment standards risks, unpaid overtime is a very big one. We've seen this so many times in our practice, working hours and overtime going undocumented and unpaid. And there's a very popular misconception that salaried employees, for example, aren't entitled to overtime. Absent certain very specific exceptions, a lot of salaried employees actually are entitled to be paid overtime pay for hours that they work above 44 hours a week. And with remote work, it's still challenging for a lot of employers to track exactly when employees are working. And some employees may be, taking a break around dinner, but then going back to work later on and not necessarily tracking their time in timesheets because, for whatever personal reasons, they're not following procedures, or some employers don't have those robust procedures in place. These can end up as employment standards claims of thousands of dollars of unpaid wages. One that immediately comes to mind is one of our clients received a claim for unpaid overtime and unpaid public holiday pay, where an employee said that they were working at times when the employer didn't expect them to be working. And the amount claimed was upwards of $90,000. Now, ultimately, it wasn't successful for a lot of reasons, but in a different set of circumstances, those kinds of claims can be successful, and employers can find themselves having to pay out very substantial amounts of overtime. As a result, employers need to be really conscious of how they're tracking hours worked and ensure that overtime is only worked with approval and that overtime policies are really airtight. Now, this doesn't mean that if an employee has worked the overtime without approval, that you don't have to pay it. Because they've worked the time, they're still entitled to the pay. But if an employee isn't following policies and getting approval in advance, they can be disciplined. And in fact, they should be disciplined because there are certain expectations in terms of the employment relationship, and they're not following them, which can lead to liability for the employer. Additionally, technology and data security has remained a pain point. Employees who are working remotely may have access or do have access remotely, sometimes through personal devices, to employer service servers and employer data. And this does create a risk. So to the extent that there hasn't been recent refreshing of security procedures, training on what employees are expected to do in terms of security and confidentiality, employers would be well advised to make sure that this is top of mind, because for a lot of employers, they talked about this early on in the pandemic, but now again, we're going on close to 2 years, and sometimes employees need a little bit of a refresh. And employers need to ensure that they can remotely access employees' devices if they need to access information and an employee needs to go on leave, for example, or where an employer has concerns about things like fraud or misappropriation of information, which might be more rare, but is still quite serious. Even though there have been a lot of challenges, there are a lot of opportunities for employers to be found in what's resulted from the pandemic. Some employers have found that they've really benefited from adopting remote work. There may be a comparative advantage to them compared to other employers in their industry. And again, with more and more employers struggling to find talent, any sort of advantage that you can offer means that you have a better chance of improving your own candidate pool. We've seen numerous studies now highlighting the shifting preferences of Canadian workers to remote work, and remote work being a selling point for potential employers. Offering remote work opportunities, therefore, as I've said, can make a business more attractive to really top candidates, and allowing remote work that's flexible to employees' needs might limit staff turnover. For some employers, there have also been significant cost benefits to moving away from traditional workspaces. Remote work offers the potential for employers to downsize their physical workplaces and limit traditional brick and mortar related operational expenses. So with some larger employers, what we've seen is, renting out pieces of their office space to others, putting in a hybrid model where employees might be sharing spaces, sharing desks, which of course means, some added complications initially in terms of startup and cleaning, scheduling, things like that. But some have found that, again, this is really working for them. And after the initial costs of helping employees get set up at home, they're finding that there are really cost benefits to remote work, and that employees are more productive because the time that they're not spending doing things like commuting or chatting during coffee breaks, they're spending time working. Now, this can have negative impacts as well, which we'll touch on in a little bit. But generally, there are some opportunities to be leveraged for employers. However, employers really have to lay the foundation to avoid foreseeable liabilities and take advantage of these opportunities. And really, the key thing here is policies and formalizing any procedures that you intend to take going forward. Because as I mentioned, and as I'll probably say a couple more times today, a lot of the start of these practices was very reactive. Employers that transitioned to remote work did it because they really had to. And so Even if it's been working, that doesn't mean that it should continue in a potentially ad hoc manner. Employers would be really well advised to sit down, formalize processes, roll them out, and train employees on them. Make sure that the expectations are clear and that the reasons for the expectations are clear as well. For some employers, indefinite remote work just isn't going to work. And simply telling employees we're going back to the office may not be very well received. But if you can explain, here are the impacts we've had on productivity, here are the impacts we've had in terms of employee morale, with employees feeling isolated from each other and not really having that team environment. Here's how we haven't been able to do some of the things that we used to do well before the pandemic because we haven't interacted with each other as closely or as in person, or we haven't had access to resources. Being able to make those arguments is what really will sway employees in the long run so that they can understand. Because the key issue that employees have communicated and that employers have noticed is transparency. So having a clear set of guidelines and having them really communicated and well socialized will minimize pushback. And ultimately, again, setting all these ground rules is very key, but making sure that you're communicating them is really the most important piece, because you can have a perfect policy, perfect procedure that addresses all of the liabilities. But if employees don't know, if they don't understand, if they haven't had an opportunity to ask questions and have any doubts reconciled, it's not going to do for you all that it could do in terms of making sure that liabilities are addressed and that you're not receiving pushback from employees in terms of how you're going to be moving forward. Now, another thing on the heat map, as I mentioned, is vaccination. And this has been a hot topic for employers, employees, pretty much everybody right now, and for some time, because again, with respect to vaccination, the goalposts keep changing, and what's relevant to employers, what obligations apply, also keeps changing. So, to give you a little bit of a snapshot of where we are, right now, there's no general requirement for vaccination in employment in most contexts. Certain federal government employees and employees working in federally regulated industries have a legislated vaccination mandate that's in place, but provincially regulated employees generally aren't going to be legally required to be vaccinated in Ontario or in any other Canadian jurisdiction. However, provincially regulated employers are increasingly being required to implement COVID-19 vaccination policies, which have to contain certain prescribed elements. And so the vaccination policy requirement isn't necessarily a vaccination requirement. Um, in Ontario, for example, the government amended one of its regulations in late August such that all Ontario employers are required to follow any advice and recommendations given by the Chief Medical Officer of Health or by a medical officer of health in their public health region with respect to implementing and ensuring compliance with a COVID-19 policy. Therefore, where a medical officer of health in your public health region has recommended that employers have a COVID-19 vaccination policy, and that policy includes certain elements, that's actually a legal requirement. This has already occurred in a lot of regions. Some of the ones that may be relevant are Toronto, Peel, and Halton, all of which made this recommendation in or about late August. But there are other regions in the area where it's not required. So for example, in York, there's still no obligation for all employees to have, for all employers, sorry, to have a vaccination policy. Additionally, given the regional variability, Ontario employers should really consider whether there are any vaccination requirements for their own public health region. And even if they aren't, given how quickly things have been changing and how vaccination has become more and more of a key thing to discuss and a key driver of a lot of policies, a key element. Employers should be aware that some of these vaccination policy requirements could be coming to them. And so employers would be well advised, and in a lot of places are required to implement and enforce vaccination policies that require employees to provide proof of vaccination or proof of a reason that prevents them from being vaccinated. In a lot of these regions, what employers are required to do is require employees who may not be vaccinated for certain reasons to complete an educational session that explains the benefits of COVID-19 vaccination, how it works, what some of the issues may be. And in a lot of instances, unvaccinated employees may be required to undergo regular antigen testing. So again, just to be clear, it's not that employers should have necessarily a mandatory vaccination policy that says you must be vaccinated or you can't work, subject to human rights exceptions, but vaccination stances from the employer should be clear, and how the employer is going to manage health and safety related issues related to vaccination should again be clearly communicated. Now, I also do want to note that there are certain sector specific requirements as well. Healthcare, childcare, education, home and community care. These are areas where the government has directly said, here's what you need to have in your vaccination policies. Again, not necessarily mandating vaccination, unless the employer has chosen to do that for its own legal, strategic, and business reasons. But having the approach documented and explaining what employees do need to provide or do not need to provide to the employer. So the biggest risk with respect to vaccination really here's sort of the again heat map or the key issues that we've seen employers having to navigate. The key issue for a lot of employers has been that this is really an unknown. And it's only very recently that we've seen law with respect to mandatory vaccination policies in particular, and whether or not they can be enforced, and what the concerns and liabilities related to doing so may be. And ultimately, it's panned out in ways that we would have expected it would, in that it's going to depend on the context of the particular workplace and the reasoning and necessity behind a vaccination mandate. So from an employment law perspective, there are a lot of legal considerations that employers need to make before they decide whether they're going to implement a mandatory vaccination policy or whether they are going to just have a vaccination disclosure policy that says you have to tell us if you're vaccinated, and if you're not, we may need you to do regular testing. The first that we have here on our list is human rights related liability and accommodation needs. So as I've mentioned, and just to put a finer point on it, no vaccination policy can be absolute. All Canadian employers have human rights obligations and a duty to accommodate employees to the point of undue hardship. Employers who fail to accommodate employees to the point of undue hardship risk facing discrimination claims. And really the two areas where this is most likely going to be claimed is disability and religion or creed. With respect to disability, some employees may go to a medical professional who will provide evidence of a medical exemption to COVID-19 vaccination. And the Ministry of Health has actually published an Ontario guidance on certain things that will necessarily require a medical exemption, certain conditions that an employee may have. Generally, the Ministry of Health has indicated that there are a few conditions that may actually warrant a medical exemption, but this isn't legally binding, and a medical professional might have a different opinion. So that said, consider this document, but also consider that accommodation needs to be done on a case-by-case basis. And where an employee is saying that they have a medical need to be exempt from vaccination, employers should make sure that they're getting evidence of that by way of a doctor's note. And if they have concerns about the doctor's note in that it's not specific, for example, it might not indicate if this is a temporary need or a permanent ongoing need, Employers should seek legal advice because accommodation can be very complicated, and should ensure that they seek all the information that they need from the employee, keeping in mind that with disability, you're not entitled to diagnosis information, you're only entitled to prognosis information. So you can't actually ask the employee what the condition is that prevents them from being vaccinated. With religion and creed, which is the other area, this relates to having a sincere and deeply held belief that's integral to a person's identity, self-definition, and fulfillment, and has some nexus or connection to an organization or community that professes a shared system of belief. So that creed can be religious, it can also be a non-religious belief system. And what's important for employers to note is that the Human Rights Commission has now explicitly said that a person who chooses to be vaccinated based on personal opinion doesn't have the right to accommodation under the code. That is still actually much more complicated than it sounds, because there is work to be done in parsing out what's personal belief and what is creed. So the other thing to keep in mind is that even if a person can show that they were denied a service, or that for employers, what's relevant is that they're denied employment because of a creed-based belief against vaccinations, the duty to accommodate doesn't necessarily require that they be exempted from vaccine mandates or certification requirements or COVID testing requirements. The duty to accommodate might be limited if it would significantly compromise health and safety to the point of undue hardship, such as during a pandemic. But again, this is a case-by-case analysis, and employers should make sure that they're taking these requests in good faith and not prejudging them. Another area where employers face liability is potential constructive dismissal claims. And we still haven't seen definitive case law that makes it clear whether mandatory vaccinations would provide employees with a basis to claim constructive dismissal in the kind of circumstances that employers are operating in. Likely, again, it would be a case-by-case analysis, but generally constructive dismissal occurs when an employer makes a unilateral change to a fundamental term or condition of employment. And when this happens, an employee has the right to treat their employment as if it's been terminated. So when considering mandatory vaccination for existing employees, employers should turn their minds to what would happen in the case of their particular workforce. What's the liability for constructive dismissal? What might the cost be? For unionized employers, the issue isn't really constructive dismissal, but employers in unionized workplace settings need to consider whether there are any applicable collective agreement terms that may restrict their ability to impose vaccination requirements. And generally, these tend to be challenged on the basis of exercise of management rights. We have actually now seen case law very, very recently on this topic, as I mentioned, and generally the cases have gone both ways in terms of finding that mandatory vaccination policies should be upheld or not upheld, depending on the particular context. So in cases where a workforce might be entirely remote or largely remote, there's not much interaction and not much health and safety risk, arbitrators have found that really it's not reasonable to impose a mandatory vaccination policy. In situations where employees might be required to go to other sites or provide services to clients who themselves require vaccination to enter their sites, we've seen that mandatory vaccination policies might actually be justifiable and might be upheld. So again, employers need to really consider their own particular context and whether their policy is reasonable. And part of how this is proved is, as I mentioned in other contexts, making sure that you're really communicating the underlying reasoning for why you may need a particular policy. If you've determined that health and safety requires you to have mandatory vaccination in order to demonstrate that you've taken all reasonable precautions to ensure the safety of workers, this is something that has to be clearly communicated to employees, and exactly what it is about the way that you work that's led to this conclusion. The other thing to keep in mind is that really an opportunity for employers exists here to revamp some of their employment related documentation and, for example, employment agreements. Because while there may be constructive dismissal related risks to imposing mandatory vaccination on existing employees with whom you've already established the terms of the employment relationship, there are much less inherent risks in imposing vaccination requirements for new employees. Obviously, measures need to be taken to make sure that you're not discriminating in hiring. So you have to be careful what questions you ask. And generally, it's not advisable to ask about vaccination status prior to hire. But employment agreements can contain a vaccination requirement as a condition of employment that makes it clear that, subject to a human rights exemption, employees have to be vaccinated as a condition of employment in order to actually work. And that, again, carries a lot less liability if an employer is able to make sure that they have an updated employment agreement that employees sign off on and agree to this, because then employees are going to have much more difficulty contesting this kind of requirement. So again, consider your specific circumstances and make sure that your policy is reasonable given the kind of work that you're doing, and the kinds of obligations you have to ensure health and safety. As I'd mentioned, another issue that a lot of employers have had to deal with is conduct in the workplace. And because of the COVID-19 pandemic, conduct-related issues have manifested in a couple of specific ways. Really, one of the major forms of misconduct has been health and safety related. And this really refers to failure to abide by health and safety procedures. Employees who might not be advising when they might have tested positive for COVID-19, employees who might not be doing screening as required. And so it's also becoming more commonplace as certain employees feel entitled not to follow certain COVID-19 protocols because they might see some others not following them. The issue here for employers is that a failure to be as responsive to certain forms of potential misconduct can result in significant liability. So if you do require masks in certain areas of your office and you find that employees aren't wearing them, talk to them. But if that doesn't help, make sure you're imposing discipline, make sure you're re-socializing requirements, and make sure that you're making expectations clear so that the violations of policies by some don't lead to bigger problems in terms of health and safety concerns and misconduct. We've also seen, as a result of the pandemic and how the pandemic has begun, an uptick in workplace harassment and discrimination claims. Early on, there was discrimination against certain groups of people because, due to ethnic origin, other colleagues assumed that they might be more at risk of COVID-19, or they may be more likely to spread COVID-19. Additionally, there may be some misconduct that's on the rise because of the inherent anxieties caused by the pandemic. Many of you, or most of you probably will have heard of the discussions about the echo pandemic of mental health, which really started shortly after the COVID-19 pandemic, but increasingly people are feeling the strain of the pandemic. And sometimes this is manifesting in people behaving out of character, losing their temper, being harsh with each other. But while, this is something that employers can predict, and there are clear reasons for this, some that may actually trigger an accommodation need because they might be a true mental health concern. Employers need to be proactive and responsive to these kinds of issues because a failure to properly respond to these complaints can lead to liabilities, and on a practical end, to reputational damage as employees become doubtful of what the employer is doing. Additionally, we've already discussed that remote work creates new considerations, and some of these might be related to harassment and discrimination claims. They may be manifesting in a different way. People can feel mistreated, harassed, and discriminated against in the remote work context through video chats, emails, and we often see these types of complaints around virtual communications. So to the extent that an employer doesn't have a virtual communication policy, this is something that an employer would be well advised to consider. I'm going to move through the rest of these items pretty quickly because I do want to make sure that I leave some time for questions. But the last conduct issue that I really want to touch on is vaccine related tensions. So this is an area where we've seen quite an increase in complaints and expect to see more complaints, quite frankly. We're currently involved in an investigation into a complaint of harassment and discrimination at a large company that involved a very senior executive making comments and behaving allegedly inappropriately towards a subordinate employee when the executive found out that the employee was not vaccinated and then engaged in yelling, gossiping, and a whole bunch of other behaviors that came about as a harassment and discrimination complaint that employers are needing to deal with. And so, particularly when it comes to supervisors who are really your workplace first responders, your front line, it's very important to make it clear that comments and conduct related to vaccination status can easily spark situations where employers may need to step in and investigate. And so these kinds of things can't be tolerated. And again, really the best way to address this is to clearly communicate expectations. Review policies. Make sure that your harassment, discrimination, conduct related guidelines are up to date. Train your staff on them to make sure that they understand, and train your managers to make sure that they know how to role model all the behaviors that you need them to role model, and also how they can assess if misconduct has occurred so that they can act on it and not create liability for themselves or for the employer. And to the extent that employers haven't had a recent opportunity to take a look at their investigation procedures and make sure that they're prepared to respond to any misconduct in the workplace, this is something that employers would be well advised to do, because investigations are becoming a very commonplace part of how employers do business. And being caught off guard, not knowing, who might be qualified to investigate, what training might you need for an internal investigation, where might you get an external investigator, can make these issues even more complicated for employers. Which can be a problem because we're really finding that the costs of mismanaging investigations are ever increasing. So as a final point, I just want to touch on the Working for Workers Act, which is a new legislation that many pieces of have really been prompted by the way that the pandemic has changed the way that we work. So this is a hot off the press. It was introduced in late October and it actually passed third reading earlier this week. So it will officially become law very, very shortly. It implements a couple of key elements, including right to disconnect laws in Ontario, which are going to require employers with 25 or more employees to have a written policy about employees disconnecting from their jobs at the end of the workday. And this is, again, really in response to the fact that employees have been working all hours. Many are feeling burnt out. In terms of what content might be necessary in the policy, this is something that the government is going to introduce through regulations later on. But very likely, the ones who are going to benefit most from this policy are employees who work 9 to 5 jobs and wouldn't generally be expected to or don't expect to be working in off hours. These are the employees that employers will be prohibited from contacting in certain circumstances. Additionally, this legislation includes a ban on non-competition clauses, which are a type of fairly strict restrictive covenant that prevent employees from competing with their employer after they leave their employer. And so this essentially would prevent people from exploring other opportunities. And so the government has imposed this ban to make it easier for workers to advance in their careers. As the legislation was reviewed by the committee and it went through the legislative process, there was an exemption created for executives. So employers who do use these kinds of restrictive covenants will still be able to do that in the case of senior executives. And while this bill includes a lot of different requirements, really the last key one that I'll address is that it would require business owners to allow delivery workers to use a company's washroom if they're delivering or picking up items. And this is to support them in making sure that essential supplies and economy are ongoing throughout the pandemic. And this, of course, has health and safety implications for employers that may not have planned to allow visitors into the workplace. So, with respect to all of these items, employers would be well advised to reassess their policies to make sure that they have a policy in place regarding the right to disconnect if they have 25 employees or more, that they've addressed the washroom access, and for employees that may have non-competition clauses in their employment agreements to make sure that they fit the exemption of senior executives or that those are removed. And so before I answer some questions, I do just want to let you know that if you're interested in having more information about any of these topics, we do have a blog where we've been writing extensively about COVID-19 related developments. We do also publish newsletters. Our most recent edition of our newsletter is a special edition on workplace investigations that talks about how to conduct them, when you may need to conduct them, what the liabilities are related to getting investigations wrong. But our upcoming newsletter in the new year in January will be a year in review newsletter where we address sort of the biggest issues that have arisen during the year. So keep an eye out for that. And with that, I will turn to questions. I'm just going to pull up my Q&A box here. So the first question that I have here is federal employees are required to be vaccinated, a bona fide condition of employment, correct? So federal employees in most circumstances are going to be required to be vaccinated because the government has said that for its own workers, it's going to be implementing a mandatory vaccination policy. For some federally regulated workers, and I should say I can answer these questions generally, but these answers really aren't legal advice. They're intended as information. For very specific situations, you may need to get legal advice because there may be information missing. So on a high level, yes, there are requirements for federal employees to be vaccinated. The requirements may vary because some employers have chosen to go above and beyond certain requirements. And but where a vaccination mandate exists, that is something that an employer can certainly take advantage of and really can't deviate from. If the government has told you in a certain sector that employers have to be vaccinated, you can't allow employees to not be vaccinated because then you're in violation of your legal obligations. The next question we have here is, can employers is it correct that employers may not pay employees less for working from home? And that's one of those kinds of situations where it really depends on the specific context. You can't unilaterally decrease salaries because where you unilaterally decrease remuneration, that's going to be potentially constructive dismissal. Again, it's a unilateral change to a fundamental term of employment. To a certain extent, it depends how much you're decreasing the salary by. If it's less than 10%, in some cases, it may not trigger constructive dismissal. If it's over 20%, it almost certainly will, and 10 to 20%, there tends to be quite a bit of variation depending on the other circumstances. But in certain circumstances, employers and employees may agree. And we've seen this in certain contexts where some employees have said, well, I don't want to come back to the office. I'm thinking of moving to, usually a small town some hours away from a larger urban center. And in those cases, employers have been able to negotiate with employees and say, okay, you don't have to come into the office, but we're going to have to change your duties and responsibilities. And if this is the kind of arrangement you want, your salary will be lower. So again, depending on the specific issue, there may be some circumstances where you can do this, but this is something that I would recommend that you obtain legal advice from whoever your counsel may be, or just generally make sure that you've thought out the strategic implications and that there aren't any other issues that can trigger liabilities. And I will turn it over to Angelica to formally close out this webinar, because I know that some of you might be leaving at 11 because you have other obligations, but we will be staying on for a few more minutes to answer questions after that, as I understand it.
Awesome. Thank you so much, Alex. So let me just say that we ask that you take a few minutes to answer today's exit survey questions and let us know where we can improve and what topics would be of interest to you in the future. Our next webinar is scheduled for Thursday, March 3rd, 2022, and will be on navigating our mental health during and post-COVID. So be sure to mark your calendars. For more local, relevant, and timely labor market information, you can find us on LinkedIn, Twitter, and Facebook. We are at Working in Peel Halton, or you can go to our Working in Peel Halton website, which is workinginpeelhalton.com. On behalf of myself, our speaker, Alex, and the entire team at the Peel Halton Workforce Development Group, thank you so much for joining us and spending the last hour with us. And we hope you have a great day and stay safe. Thank you. So we'll turn it back to Alex just to finish off the Q&A.
Thank you, Angelica. So I'll just keep going through the questions. And I will say, to the extent that a question is very specific and related to specific circumstances, as I mentioned, I can't necessarily answer that because this is intended for legal informational purposes. So if you do have a specific question, I would encourage you to reach out and obtain legal advice with respect to your specific situation. So moving on to the next general question we have here. If an employer requires an employee to return to work in the workplace, can the employee refuse, citing health and safety concerns about working with unvaccinated people? That's a great question, and it's certainly one that we've had quite often. If an employer asks an employee to return to work and an employee has health and safety concerns, they can refuse to work. And there is a formal process that has to be followed under health and safety legislation that involves an investigation by the employer, seeing if there are any issues, addressing them with the employee. And then if the employee still isn't satisfied and doesn't want to come back, it can be escalated to the Ministry of Labor. The existence of unvaccinated people in the workplace isn't necessarily going to carry the day, but certainly it may make people be concerned, especially, again, as we are in a fourth wave and cases have been going up. If the employer feels that there are health and safety measures in place that are sufficient, so physical distancing requirements, mask wearing requirements, a lot of employers have implemented rotations so that, again, physical distancing can be ensured, people aren't in the office at the same time. An employee can raise the issue and they can try to refuse, but they may not be found to be in the right, and they may be required to come back to work. Ultimately, sometimes employers are concerned about getting the Ministry of Labor involved and having an inspector come in and look at the situation. But in certain circumstances, if you're certain that you've done your due diligence, that you've taken all reasonable precautions to protect the health and safety of workers, it may be beneficial to have the ministry come in, because then the ministry can say, well, actually, there's no health and safety concern here. And again, we've seen that happen where employees have refused to come back. The employer has followed the formal work refusal process, and then ultimately employees have been told that there's no safety, health and safety concern, given what the employer has done to ensure health and safety. And employees have had to come back to work, and employers have been able to point to that assessment to say, look, we're confident in what we've done. And in fact, the people who decide on whether or not there are issues here are also confident that we've done everything that we need to address health and safety. The next question we have here is there a deadline for paying out overtime? Overtime is wages, so technically it has to be paid out when the employee works on the subsequent pay stub. There may be some exemptions. So some employers may have an overtime averaging policy, which averages overtime worked over a number of weeks, in which case it might be a little bit different. Um, there may also be employers who have a banked time off policy. So if employees agree in writing, they can receive lieu time instead of overtime pay. And that lieu time has to be taken in a certain amount of time. And generally the default is 3 months, that they can agree to take it within as long as a year. And then if they don't take that time, then there are obviously some implications there as well. But in terms of a deadline, if overtime hasn't been paid out, it really should be paid out as soon as possible, absent some of these specific um, circumstances that may be at play. In terms of deadline for employees making the claim, it is 2 years. So any overtime that hasn't been paid over the last 2 years is overtime that an employee might be able to make a claim for under the Employment Standards Act, which is where employees most commonly go for this, because it's a much faster process than, say, going through the entire process of going to court and making a legal claim at, small claims court. If it's under 35,000, I believe, is the current limit, or um, just the standard court process if it's more, because those were relatively backlogged, and the timelines were very lengthy before the pandemic. Now they've just gotten increased. So that's where employees tend to go. It tends to be a much faster process for the parties. The next question we have is, have any common law cases shown that a mandatory vaccination policy in a workplace that can allow distancing and work from home is not enforceable? So most of the decisions that we've seen with respect to mandatory vaccinations, the ones that are just coming out now, are arbitration decisions in a unionized context. So in terms of decisions from courts, we haven't really seen any of those because, again, the litigation process is much lengthier. However, the decisions have shown us that in workplaces where employees can entirely work from home, may not interact with each other, it might not be reasonable to implement a mandatory vaccination policy, because the impact of the mandatory vaccination policy is disproportionate to the additional health and safety gains that it would allow for. So this is why, as I mentioned, it's really key to look at the circumstances and consider, to what extent is work from home part of how you conduct business? To what extent is physical distancing possible? Because it also is going to depend on what your office space is like. If it's a pretty small office space, people are going to be, passing by each other or working in close proximity. It might be a little bit of a different situation than if you have 10,000 square feet and 10 or 15 employees in it, for whatever reason, depending on how your office is laid out. Our next question is, how would you address an employee that's unvaccinated refusing to take a PCR test? And so this is another one of those situations where I would say it depends. It depends on what the specific context is here. And perhaps if this attendee who asked the question is still here, if you want to ask a clarifying question, but generally, if there's a requirement to be tested, it might not necessarily be a PCR test. So in a lot of workplace contexts, employees might be able to take rapid antigen tests. If they're exhibiting symptoms and they don't want to take a test, they may be able to self-isolate. So, it's not necessarily going to be the case that an employee needs to take the PCR test specifically. The next question we have here is not asking for vaccination status until after hire. And the question is, what if it's a requirement, such as in a customer-facing position that can't work remote, like working in an airport? Even where there is a mandatory vaccination situation, it can be tricky to ask about vaccination status beforehand because, again, there may be a health not a health and safety, sorry, a human rights related need that can be accommodated. So the reason that I suggest is you may not want to ask about vaccination status. That might lead to a discussion about disability or religion or creed, and that can lead to discrimination concerns. Putting out an offer to a candidate, and you can send out the employment offer some weeks before you want them to start, that makes it clear that vaccination is a condition of employment, but that you will accommodate any sort of health and safety requirements to the point of undue hardship is a lot less risky in terms of having claims, because it's something that you can demonstrate in writing exactly what was discussed. It's more difficult for a candidate to claim that something was done that was improper. And ultimately, if it may be that even if there's a vaccination requirement, you might be able to accommodate. If you can't, that's what the condition of employment is there for. And if the condition of employment can't be fulfilled, then in that circumstance, the employee wouldn't be able to work, and the employment relationship would not proceed forward. So we have another question here where an employer put a requirement for the employee to never work against the interests of the employer even after employment has ended. Is this a form of non-competition agreement, and is it now banned? Again, that's really going to depend on the full wording and exactly what it says. Essentially, it could be a non-competition requirement. So a non-competition is any restrictive covenant that essentially says that the employee can't compete with the employer. And it's the most restrictive of the types of restrictive covenants available to employers. The ones we traditionally tend to see are confidentiality clauses, which are the least restrictive, non-solicitation, which refer to the employee not being able to take its former employer's employees or clients when they leave, not being able to solicit them to go with them. And non-competition, which says you can't compete. Non-competition provisions generally are difficult to enforce because courts tend to be averse to enforcing restrictions on trade. So a very broad restriction, like you can't work against the interests of the employer, might have been too broad to be enforced anyway. But certainly if it exists in the agreement of an employee who isn't now essentially a member of the C-suite, a senior executive, then something like that would very likely not be enforceable. We have another question about non-competition clauses, which is what if they're already in existing contracts? Does this impact the validity of the entire contract, or is the one section unenforceable? Generally, there is a principle of severability at play in employment agreements. So if you have one provision that's unenforceable, it's not going to affect the enforceability of the entire employment agreement. But this is going to depend on how specifically it's drafted. If it's not very clear where the provision starts and ends, it's a little bit more difficult to sever. And a lot of employment agreements over the years, as a standard provision, also have a specific severability clause that says, to the extent that one of these provisions might be unenforceable, it's not going to impact the validity of the rest of the contract. However, courts aren't going to sever a piece of it. So for example, if you have a non-competition clause that's intermingled with a non-solicitation provision or something similar, you might find that the validity of that entire section might be compromised. Reviewing employment agreements and updating them, though, I will say, as a general practice, can be a good idea because there's been so much shift in terms of employment agreement enforceability over the last few years even. And so even if you're fairly confident that the non-competition provision is very narrow, can be easily excised from the rest of the employment agreement and isn't going to affect the rest of your employment agreement, it might be a good chance to take a look at everything. And, if you haven't had your employment agreements revised in some years, get a legal review of your employment agreements, because certain provisions like termination clauses, which are really one of the key reasons, in addition to restrictive covenants, to have an employment agreement to get some predictability at the end of the employment relationship, those have been, the law there has really changed. And there have been some recent decisions last year that invalidated probably 80 to 90% of termination clauses in the province of Ontario. So again, it might be that if you have this isolated agreement provision, the existence of this new legislation isn't going to affect you. It may be, again, that, if you have non-competition agreements with employees who are relatively low level, relatively junior, or your non-competition agreement or provision is not sufficiently specific, it might not have been enforceable anyway. But again, this just does provide the opportunity to take a look at everything and make sure that you've really dotted your I's and crossed your T's. The next question, I think we just have a couple more, so I will keep going for a couple of more minutes. What are the duties to accommodate if an employee claims exemptions from masking? The duty to accommodate is always going to be the same general duty, which is accommodating to the point of undue hardship. And so the process is going to be, make sure that you get a medical note that explains the medical limitation and the prognosis. So again, not the diagnosis. You're not entitled as an employer to information about what medical condition has led to this, but you can ask, what specifically is the medical limitation? Is it that they can't wear masks ever? Is it that they can only wear masks for a very limited period of time? And so the process would be to get the information, and then whether or not there's a duty to accommodate a specific employee, again, is going to be entirely case by case, because it's going to depend on the specific medical limitations, and it's going to depend on the nature of the work that the employer does and the particular duties of the employee. We have another question here. Currently, regional health units do not advise that rapid tests are used on vaccinated workers. Are there any concerns with a vaccinated worker taking a rapid test versus a PCR test to verify if they have COVID-19? So the fact is that tests and test required tests are evolving. There are increasingly different kinds of COVID tests that have become available. Ideally, if it's a concern of symptoms, the PCR test is always used to verify. Rapid tests are considered to be less accurate. So if an employee does have symptoms, whether or not they're vaccinated, if they've been taking the rapid test and the rapid test comes back positive, they really should be going to get a PCR test to verify. So ultimately, that should be that should be where you end if there are any concerns, because that is the test that we know is more accurate. Realistically, there may be situations where a rapid test is appropriate, and in a lot of circumstances where regular testing has been implemented. So for example, in childcare, currently there's an obligation for unvaccinated employees to be tested 3 times a week. The fact is that given that PCR tests have to be sent to a lab and have to take 24 to 48 hours to be processed, it's just not feasible to get a PCR test done every time. So you can leverage the rapid test because doing the test more frequently makes it more likely that a positive situation, a positive case will be caught, but then ultimately it should be verified with a PCR test. And so the final question we have here is, can you include in a job posting that vaccination is a condition of employment? And if so, how can you ask during the initial screening process if a candidate is fully vaccinated? Generally, yes, you can include in a job posting that vaccination is a condition of employment. But even if you include it, I would say how you might be able to ask it and whether you should ask it is going to depend on exactly what the position is, and you should um, again obtain legal advice in terms of your questions and any probing questions you may ask, because you don't want to ask something that you're not um, information that you're not entitled to. So if you're making it clear in your job posting that vaccination is a condition of employment, you should also make it clear that the organization is going to accommodate any human rights related needs as it is required to, so that you're not in a position where somebody can claim that you've actually discriminated against them based on, again, disability or more rarely creed or religion, by not acknowledging that you may have to accommodate these kinds of exemptions. And so that was our last question. So I want to thank you all, and thank you to those of you who stayed on. We will be sharing the slides. I'll be sending them over to Angelica. And in the slides, you have our contact information here. So should you have any more questions about the content that was covered here, as I mentioned, you can visit our website. You can go to our blog, take a look at the newspapers. And if any of you have any questions directly related to the content in this webinar or HR law implications of COVID-19 generally, please feel free to contact me as well. My contact information here is on the screen. And thank you again for joining me for this, I guess, almost hour and a half now. And thank you again to Angelica and Peel Holton Workforce Development Group for having me today.